And now, in studio, bringing his Midwest values from the Show Me State to the land of San Diego. He's a triple threat, licensed as an attorney, mortgage broker, and a top producing realtor who's crushing the competition. Here to deliver you what's happening in the trenches of the market. Your host, Michael Gaddis.
Welcome back to the Michael Gaddis Show on AM 1170 The Answer. I am Michael Gaddis of michaelgaddis.com and frontierloangroup.com. We're continuing our conversation with Pat Hodgkin of firstamericantrust.com. And before the break, Pat was talking to us about exactly what a successor trustee is. So to summarize what you were talking about before the break, basically a trustee is somebody who's in charge of the trust, the person in charge of a trust. And when a trust is established, the person who establishes the trust is usually their own trustee. They're usually the one in charge. You are somebody that would take over, in the event of their death or incapacity. You were the one that would become in charge of that. You would be then in charge of the actual trust assets.
That's correct. And as a fiduciary, we have those fiduciary legal responsibilities to maintain it and to make sure that we know the law, that we act in accordance to the law, as well as in accordance to the trust. And that's part of the problem with being a successor trustee and having one of the kids as a successor trustee.
Well, and I think this is a really important part of this, because you're an independent third party. You're not related to the trust, anybody in the trust whatsoever. So what I think is important about that is that you are able to basically establish a non-emotional relationship with the trust. You're not attached to anything at all, unlike children. Now, I know what everybody's thinking out there. Everybody's initial reaction is, well, if I'm going to establish a trust, I'm going to put one of my children or maybe all of my children involved. I can tell you with 99% certainty, and probably it's because basically what I do, I get a lot of phone calls from people. And one of the phone calls I get it's either one of two. Either there's too many, let's say they put multiple children in the trust as the successor trustees. They don't get along. They don't agree on anything. I have that situation going on right now. Right now with the house in Oceanside, a lady called me, and there are 3 people that were named as successor trustees in this trust. 2 of them agree, the other one doesn't, and they cannot get anything done, and they need to try to sell a real estate asset, and it is causing a lot of problems for them. They're extremely stressed out because there's a lot. They're supporting the mortgage on this. Their mother had passed away. The house is there. Nobody lives in it, and so in order to keep it afloat to try to sell it, basically somebody has to pay the mortgage in the meantime, and 2 of them want to sell it. The other one doesn't. And the one that doesn't live in the state. None of these people live in the state. So they're continuing to pay this money, and it's just nothing is moving forward. So they call me frustrated and upset, about what they're going to do. And the other option is when a person picks one child and not the other children. And then that creates kind of animosity between the children. Like, well, I don't know why my father put my brother as a trustee. I was the one that spent all my time with him, but he's picked him. So I'm going to illustrate a point for Pat, and then I'll let Pat comment on this. As you know, I'm a real estate broker. I sell both commercial and residential properties. Late last year, I sold a property up in Los Angeles. It was a commercial property. The commercial property, it was a commercial residential property. The person who owned the property passed away, and she had a trust set up, and she had an independent third party, basically an attorney she had to establish her trust. And the kids came to me, and one of the children specifically says, well, I don't know why my mother picked this guy to be a trustee. I don't know why he just didn't pick us. Well, this was early on in the transaction. Well, as it turned out, this real estate transaction turned out to be extremely complicated. It got put in REIT because there was deferred maintenance, which is the city of Los Angeles' basically way to slap landlords on the hand if they're not keep maintaining their buildings, and it is a quagmire. And I use that word twice in the show so far, quagmire. It is a serious quagmire. And so, this one was, and they had stopped making the payments, so there was a foreclosure pending. There was all of this stuff going on. And the trustee was trying to work with the children, the 3 children, to kind of make decisions. And what it was coming down to is that there could never be a decision. The daughter wanted to sell it. One of the sons absolutely did not, and there was one that was kind of in the middle, going back and forth. Now, at first it was kind of just, it was informational, it was friendly. Towards the end, it started getting where nothing was accomplished. We were facing foreclosure dates, we were facing REIT violation hearings, all of this stuff because nobody could make a decision. I finally had a conversation with the trustee and said, look, you're going to have to step up and make a decision. They will never, ever make a unanimous decision together. They will never be on the same page. You are going to have to, as trustee, make a decision, or this thing is going to go south really fast. So he eventually did make a decision, and of course, not everybody was happy, but in this situation, I mean, this is exactly why the mother picked an independent third party to be a trustee. And I think that unless you really understand that, that children have, they have emotions, they all have these pent-up angers, and, and there's jealousies and all kinds of things that get involved. And in this case, if they would have basically ruined their entire inheritance fighting over things if there wasn't an independent third party involved. So, Pat, I'll let you comment on that.
No, you're absolutely right, Michael. And I think that, we've seen so many cases of this, situations where I always say to people, let your kids be really mad at us. We don't care. They can be mad when we make the correct legal and correct fiduciary decision, but don't break up your family. Once you're gone, most parents want their kids to stay together, to want to keep that family unity together. And if you appoint a third party, you can give them a chance to do that. And it doesn't matter how much money you have. People say, well, I don't have that much money for the kids to fight about. Listen, I know a situation where it was over $10,000. And there was really nothing. There was a house for $60,000 that went to the eldest daughter. And the younger daughter, there was $20,000 in a bank account. And the youngest daughter was very upset that she did not get a chance to see anything in the house, to get anything in the house, and she didn't think that she got the right amount of money. This are two sisters who have been best friends since birth, who will never talk to each other again. They haven't talked to each other in 4 years. And so it doesn't matter how much money you have. Don't say, well, I don't have, you have to have billions in order for the kids to fight. It's not true. Any amount is going to happen. And there's the liability, Michael, you kind of mentioned it. There is a liability in being a trustee as well. You have to make sure you do the right thing. So your kids can sue each other too. So whether there's one that is the trustee or 3 or 4 that are all co-trustees, you can run into that situation where all of a sudden they're suing each other, and your hard-earned money that you thought was going to be there to support your kids and your family is gone and is going to the lawyers. Sorry, Michael. But this is the situation that we see happening over and over and over again. Just go to a third party. It's going to cost you a minimal amount of money for the estate, for being a trustee, and everything is going to be worked out legally, cleanly, and properly. The kids aren't going to know that maybe there's a fiduciary tax return that's due. Kids aren't going to know that they have to file the will. Kids aren't going to know that they have to wait 120 days after they've notified all the beneficiaries. This is all things that are in the probate code that you have to do, and the kids don't know that. Well, if one child gets upset, they can pick out one little thing and go and sue. So you just don't want any of this to go on. Pick a third party, and I'm not saying you necessarily have to pick us, even though I think we're the best. Pick any third party that works for you. Interview a number of them. Find that relationship that you can have. I have very strong relationships with a lot of individuals who are still alive and well, but have appointed us. And I'll maintain those relationships, make sure that nothing's changed, make sure that they tell me when anything has happened, and so that we can talk about what changes need to be done. Do they need to go back to their attorney? So pick that right person, that right company, individual person that's going to be that good relationship with you.
Well, you're listening to the Michael Gaddis Show on AM 1170 The Answer, and my special guest today is Pat Hodgkin of FirstAmericanTrust.com. and she's talking a little bit about, being a successor trustee. And well, you mentioned something in there about fiduciary. Why don't you explain really quick, what do you mean by fiduciary responsibilities?
So fiduciary responsibility is set out by the California State Probate Code. And anybody who steps in as a trustee has that fiduciary responsibility, that you are to maintain the trust, to maintain the properties exactly the way it should be for an exact situation. So if somebody is incapacitated, you want to make sure that if they're living at home, that the real estate is maintained, and that the loved one who is living at home being taken care of isn't living in squalor, and that the property is being maintained for a later sale date. So we make sure that everything is kept up, the yard work is maintained, if there's needs painting, whatever it is, and inside, if anything breaks, we make sure that the person is being taken care of and well taken care of in a home that's clean and neat. Making sure that the investments are invested properly for the trust. So, and how many children know exactly what that means. So you have to read the trust, and you have to understand what is the right thing for investments for the individual if they're incapacitated, or for the beneficiaries upon death. So, and again, if you're not investing right as a trustee and something goes south in the market, you can be on the line. So you want to make sure that you understand what the trust says and what your responsibilities are as a fiduciary.
Well, I think the important thing in that is just keeping in mind that, an independent third party, an independent successor trustee like yourself, kind of a third party outside of the normal family, you basically have the knowledge and know-how, and you're not emotionally attached. And that, when you're dealing, first of all, a death or incapacity alone is a very emotional and stressful event. But you add in the fact that all of a sudden somebody who's got to start managing, assets and wealth when they're not, that might not necessarily be what they do for a living, it can be extremely onerous. But well, we're going to go to break now. After the break, we're going to continue our conversation with Pat Hodgkin from FirstAmericanTrust.com. You're listening to the Michael Gaddis Show on AM 1170, The Answer.